The cost to go through probate for most families is pretty significant. It is set forth in the probate code, and what appears in the probate code on the surface is a lot, but there's even more to it than what one would find in looking at the code. So, for example, when filing a petition to administer an estate through probate, attorney's fees that are deemed to be the minimum fees that are reasonable and necessary for the work and services provided by an attorney are a percentage of the value of the estate. Under the current code, it's amount equal to 4% of the first $100,000 in value of the estate, 3% of the second $100,000 of the estate, and then 2% up to the next $800,000 of an estate. If we take a really modest estate, let's say a $300,000 estate, we've got $4,000 plus $3,000 plus $2,000. So we're upwards of around, just for the attorney's fees on a very simple estate, $9,000. Under the code, the administrator who's appointed by the court to do the actual day-to-day management in terms of bill paying and selling assets and estate liquidations and things like that receives an compensation equal to what the attorney is paid under the code. Again, a simple $300,000 estate, we're at $9,000 for the lawyer, $9,000 for the administrator, already up to $18,000. Now, the worst part that I mentioned then comes in because on top of that, the court charges a filing fee for every motion that is filed in the court or petition that's filed in the court. Unusual to the probate department of the court, that fee is charged at least in a large amount every time something happens. So, for example, under current law, petition filing fee is $435 to get the initial paperwork filed. If we have to sell real estate, we may need a motion to do that. So that's $435 again to the court. At some point in time in the case, there will be an accounting that has to be approved. So we have to file an accounting with the court and get a hearing for that. Again, another $435. So there can easily be, $1,500, $2,000 in court filing fees just to pay the court for getting court orders that are necessary for the administration of the estate. The law requires an appraisal. There's an entity called a probate referee, and that person's appointed by the court. And they charge fees. Those fees have to be paid. They're not as high as what I would call a bank appraisal, but nonetheless, you're probably looking at $200 or $300 or $400 in fees that have to be paid to that probate referee for the appraisal that has to be filed with the court. One significant expense that is part of the probate process is a publication in the newspaper. At the outset, there has to be a notice published before the court can even appoint somebody. I've seen newspaper fees all over the board, anywhere from about $500 on up to $1,200 or $1,500 to pay a newspaper that is ordered by the court in order to make those publications necessary. When I have a new client coming in, we're doing a probate case, one of the things I explain is that we need to carve out probably $4,000 or $5,000 in expenses that are going to come due as the case unfolds. We need to plan for the administrative fees and attorney's fees, so several thousands of dollars. Probably on average, I'm estimating $25,000 to $30,000 for most estates. The numbers I just gave you were for a very minimal estate. And it is, again, as I've indicated, based upon the size of the estate. So it is a very significant cost, and those things have to be budgeted and provided for. By the way, those things are paid out of the top side. They're paid first before other expenses are paid from the estate, and they're entitled to priority under the code. Sometimes there are expenses that have to be dealt with. There may be mortgage payments that have to be paid. There may be car loan payments. There may be insurance payments. There may be property, all kinds of things that come up. And that can be challenging in some estate situations because there may not be any liquid funds in an estate. The estate may consist of some personal property, furniture, a house, real estate. There's no actual cash in the bank to take care of those things. Because it can take so long to go through the court process, it may require a family member to advance money to the estate in order to ensure that a property doesn't fall into foreclosure before it can be sold. Those monies can be reimbursed back to that person when the estate is in a position to distribute funds and money. But nonetheless, sometimes that's part of the planning and budgeting process of going through a probate, because there may need to be some way to manage those expenses as the case goes through the court system. And I should mention that the fees that we just talked about are what the code interprets to be minimum fees. There may be extraordinary fees or additional fees that are necessary in order for the administration. So by way of example, a recent case I had involved a family that didn't get along. We filed a petition to probate the estate. One of the brothers, bit of a bum, really, just wouldn't move out of Dad's house. He had lived there for years, and Dad had taken care of him, and he never had a job, and he never took care of himself, and now he wasn't prepared to move and wasn't willing to move. We had the regular part of dealing with the administration of the estate, so we had to add to that a separate legal case, an eviction, and what we would call an unlawful detainer. So we had to go through a whole separate court proceeding in order to get a court order for the eviction of the brother, so my client, the administrator of the estate, could get the house on the market, get it cleaned out, get it sold, so that the money from the house could then be put into the estate funds and liquidated. So in that case, the legal costs would include, not only the basic structure set forth in the probate code, but on top of that, another $2,000 or $3,000 in additional legal costs, because we had to go through other legal processes and procedures that were not typical of a normal probate case. So whenever you run into a situation where you may have extraordinary fees or costs, those are subject to court approval. The judge has to look at it, make sure it's reasonable and equitable and appropriate. But nonetheless, the fees are minimal in terms of what the court automatically will approve based upon what's set forth in the code. And a circular logic takes us back to the idea of how do I avoid those costs and fees. And it boils down to planning things in advance, setting things up that may not require probate court or being in court at all. Talking to a lawyer and doing an estate plan is not inexpensive. For most people, it's going to be $2,000 or $3,000 to do something like that to make sure that it's done correctly. But certainly, it is a huge financial savings to the estate later. Interestingly enough, sometimes I ask the question, because that'll come up when I talk to people. Do I really need to do this? Do I really need to pay $2,000 or $3,000 for an estate plan? Talk about these back end expenses of going through court and probate and what that entails. Sometimes people don't care. I've had clients tell me, "It's not my problem. I'll be dead." And I kind of say that tongue in cheek, but that's how they really feel, and there's nothing wrong with that. If they would rather keep the $3,000 in their pocket and let their beneficiaries and their kids bear the higher cost later, and they're okay with that, it's their stuff, it's their choice. There's no right or wrong answer in deciding whether or not that's the right thing to do. My job is to make sure they understand today's choice and the consequence later, and whether today's choice makes sense. And the only person that can answer whether or not it makes sense is them. Most people are going to avoid the long-term cost and choose the savings of advanced planning, but other people are fine with not doing it, and that's up to them. When we're dealing with the cost of probate administration, the evaluation in terms of attorney's fees and administrator fees are calculated upon the gross value of the estate, not the equity. So in other words, we don't deduct a mortgage from the house value. If we have a $500,000 house with a $200,000 loan on it, the fees are not calculated on that $300,000 difference on the net. The fees are calculated on the $500,000 gross value. It can often surprise people that those costs are based upon a much bigger amount, because for most people, we think of our estate in terms of what its actual net worth is after we deduct loans. But in terms of how the court is going to order fees and costs, we have to think of it in terms of what things are going to sell for before we pay those debts off.